4 hours. The renewal's coming up on 12/31, and we've got a lot going on. What I wanted to do today on the additional insured training, I know that a lot of people have contacted us over the last month or two wanting information, wanting to know what to do, wanting solutions to a lot of problems. And what I want to tell you right up front that I told the group yesterday, I don't have all the answers for you, but I just want to give you some information. We're going to do some more in-depth training because this is a very, very technical issue, and you're not going to learn everything you need to know from 1 hour and maybe not even from 3 or 4 or 5 hours, but you'll at least have some basic information. Laura, you can go on to the next slide. I want to go over, how your contracts are affected. I want to go over industry trends. I want to talk about blanket, or what we call automatic additional insured endorsements. We're going to talk a little about the endorsements that are listed on this page. And what I want to do is I want to give you, I learned something from yesterday that I need to do something more in-depth on the front end on today's session that I didn't get to yesterday right away, but I'm going to do that today by going over these endorsements that are on this page briefly for you. If you've got leases in the insurance industry, the standard endorsement you should see to provide the owner entity and the property management company entity or entities with additional insured status would be the first one, the CG, which means just commercial general liability, CG, 2011. That is an endorsement that's provided to managers or lessors of premises. So that would be the standard endorsement. Now, there are going to be insurance carriers that are going to have variations on that form number. That form number is actually what we call an ISO form, or Insurance Services Office form, and that is a kind of an industry standard, that standardization or standardized organization, and they try to make everything uniform. But there are some insurance carriers that will do something a little one-off from that. They'll use some of the wording from the standard ISO endorsement, but then use their own. But this would be your standard for a tenant giving this to the landlord as the additional insured endorsement from the tenant. The next one, the CG 2010, is the, as it says here, the ongoing operations or the premises endorsement for additional insured. So if the building owner has a tenant that invites in a subcontractor, then for the time they're on the property, the CG 2010 that would be the endorsement that would extend additional insured status to the owner and the property manager for the actions or activities of that subcontractor while they're on the premises. So while their operations are ongoing. We'll skip to the last one. Once they leave the property, then whatever their work was, let's say they put up a wall, they installed windows, they installed a staircase. What may happen long term, let's say, as I mentioned yesterday, the windows a year down the road start leaking like a sieve, then that endorsement provides what we call the completed operations coverage for additional insured status to the building owner and the property management company for the results of that work that that subcontractor did for, let's say, the tenant, or they do for the owner, whomever. The 2033, that is something that started, I've been in the industry now probably 30 some odd years, and it wasn't really around the first 5 or 8 years I was in the business, but then it kind of started slowly, really snowballed about 10 to 12 years ago, and now I would say virtually 95% of all insurance carriers use this CG 2033, which is considered the blanket or automatic additional insured endorsement, because what they tried to do about 15 years ago is they started cutting back on their clerical staff. And when I first started in the business for many years thereafter, you would have an endorsement put onto a policy for each and every building owner that needed to be an additional insured. Somebody would, years ago, actually type that endorsement, and then they went to computers and they printed the endorsements, and now they don't even want to use people to even, process the endorsements. They just want to give you a blanket or automatic endorsement, and it says basically when it's required by written contract that the party that needs to be an additional insured is an additional insured. That's just kind of a very high, 10,000-foot high-level overview of the primary endorsements that we'll be looking at today. All right, well, you can go on. Well, right there, let me tell you what we're doing today. As you know, all contracts typically have an additional insured requirement in them, and that can be a lease, it can be a contract with a vendor, providing supplies or coming in to service the coffee machines or whatever that might be, or it can be a contractor or a subcontractor. So virtually all contracts should have some type of insurance requirement in them, and I would tell you that if they don't, that should be the first red flag that that's a problem if there's not some type of insurance requirements in the contract. And then secondly, whoever is letting the contract to the other party, either a vendor, subcontractor, contractor, or if we're the landlord and you're the property management company and we're having a tenant come into the building, we should always have whomever we're dealing with name the building owner and the property management company as additional insured. So if you don't see those two basic things, insurance requirements and additional insured status, you have a serious problem. So if you even have a work order or a purchase order that doesn't have something in them, you should not be using them. That should be just a cardinal sin not to use those things. Because when you don't have insurance requirements and don't have additional insured status, anything could happen, and the party you're contracting with could be completely uninsured without your knowledge. So you need to make sure that you do have those provisions in the agreement. All right, Lily, you can go on to the next one. Industry trends. Why we're having this webinar today is because the industry has evolved dramatically, and they've evolved more dramatically in the past 10 years than they did probably for 20 or 30 years prior to that. The insurance industry is very slow to come around to trends, even if they're legal trends, to be honest with you. It takes them a long time to get used to what the changes are, to get accustomed to how to handle them, how to distribute the information to all their insureds, to their offices, to their claims people. It just takes them forever to go through that. So we've had a lot of change, particularly in the last 10 years. All right, Lori, go on to the next one. Where we used to be, when I came into the industry, it was a few years before 1985, and this was the standard insurance, additional insured endorsement used by virtually every insurance carrier in the country. Down at the bottom in yellow, you can see that this was, or it was and is, the CG, or the Commercial General Liability 2010, and it was the November of 1985 edition. So 1185 is the edition date. So anytime you see an endorsement number, it should be at least two letters, 4 digits on the front end and 4 digits on the back end. And the 4 digits on the back end are the edition date. If you don't have at least those alphas and numerics in your contract or in anything you might see, you're missing part of it. You're missing a critical part, which is the edition date, which completely changes from one edition to the next edition to the next edition, the content of the document. In this case, this was an all-encompassing endorsement. This endorsement covered both the premises exposure, the operations while the contractor was there, and it covered the completed operations piece as well. It was all in one. And you can see it's very simple. It basically said who is an insured is amended to include as an insured the person or organization shown in the schedule, but only with respect to liability arising out of your work for that insured by or for you. And your work was a very broad definition. Back then, it was both what you were doing when you were there and what resulted after you left the property. So in 1985, it was all bundled together, very simple, and pretty much anything could happen, and it didn't matter whose fault it was. If it was the owner's fault completely, the contractor's fault completely, as long as we had additional insured status and we had this form, it was virtually impossible for an insurance company to deny defense and indemnification to the additional insured party. And as you can see where it's a schedule, name of person or organization, back then, we typed these things in, and then just 10 years after that, I guess, started using computers and printing them out. But the name was typed right there where it says name of person or organization for every single owner and every single party that needs to be additional insured. That changed, and Lori, you can go on to the next. Again, this is just a list for you of the endorsements that you might see from day to day. We're just going to give you this as some type of a guide for later if you want to look this up to see what types of endorsements you're getting. But then, Lori, you can go on to the next one. This is the difference in the additional insured endorsements from edition to edition. As you can see, the 1985 edition is not even there because that's been so long ago. Very few people still can get that endorsement. It is still available, but only available, we see, to extremely large, I would say, national or international accounts, like extremely large general contractors, the big boys in the business. They can, if they want it and need it, can typically get that old endorsement from their insurance carrier, from their underwriter. And it's only because they're paying a very high premium to get it, or they're a very coveted account. But we still do see it on rare occasion. Not often, but if you do happen to see it, don't be freaked out by it because it is still around, but in very limited quantity. I won't talk about the 1993 one because that kind of went out the window as well. But the 2001, that endorsement, how that worked is the 1985 CG 2010, it actually became 2 endorsements. That one endorsement became 2 in 2001. It became the CG 2010 and the CG 2037. So as you can see, the 2037 kind of was created. It wasn't in the box at the top of 1993 when it's not there, but it came into being in 2001. So what happened is the old CG 2010, the October of 2001, or what we call the 10 of 01 edition, that became only a premises additional insured endorsement. It only applied when they were on the property. You had to get a second endorsement, additional insured endorsement, the CG 2037, for what happened after they left the property. So as you can see, the limiting language on the 2010 became to where it's arising out of the named insurance operations that fall within the policy's products completed operations hazard. That was what went into the 2037. So there was no coverage for the additional insured for losses that occurred before the construction operations on the 2037. That again went back to the 2010. So you've got companion endorsements. Now, if you want both, you want coverage while they're there and coverage after they leave for whatever may occur, then you want both the 2010 and the 2037, the 2. In 2004, that's when things really began to change. They added wording that said, the limiting language said, caused in whole or in part. What that did is that basically there was no coverage for the additional insured for either the building owner or the property management company unless the named insured, which was, let's say, the contractor or your vendor, or someone acting on their behalf, had active involvement in the loss. So if they weren't actively involved in whatever occurred, whoever was named as an additional insured, in all of our cases, the property owner, landlord, or the property manager, were no longer an additional insured under that policy. and this is my real-life example I gave yesterday. I'll probably be giving this example for the next 25 years. But we have a shopping center down in Florida that is a little strip shopping center that has a little stop and shop in it. And a few years back, Prudential, as the property owner, through their property management company, hired a porter service to clean the shopping center, to pick up trash, empty the garbage cans, clean windows, whatever it was, all that they were going to do. It was a contract with the porter service, a professional porter service. It wasn't just some guy working on his own. We negotiated it, had it. In that contract, it said that the porter service was to name the property owner / landlord and the property management company as additional insured. And lo and behold, unknown to everybody involved at the time, they had the 2004 edition of both the CG 2010 and the CG 2037. So basically there was no coverage for the additional insured unless the named insured, the porter service company, or someone acting on their behalf, had an active involvement or an active role in what occurred to create the loss. One day, middle of the day, broad daylight, a gentleman working for the porter service came out to our shopping center, and a crazy guy carrying a Bible pulled the Bible up and a knife out of the Bible and slit the porter's throat from ear to ear. And I can't say it any other way because that's just what happened. The gentleman lived. Now we are still in litigation. It's been several years. The medical bills for this gentleman they are now at $1 million. He's never got back to work. He was, I think, in his late 30s or early 40s. The guy that cut him has been deemed insane. He's been in a mental institution ever since, actually a mental prison, ever since the incident occurred, and he's been declared legally incompetent to stand trial on at least 3 occasions. The insurance company, when we tried to tender the claim of the porter suing the property owner, the landlord, when we tried to tender that to the porter service insurance company because we were an additional insured, they said, listen, we had nothing to do, neither us as a company or our employee, with this attack. It was unprovoked, not expected. We did nothing. We were not involved. We had no active involvement in the loss. He just happened to be there, and it just happened. And we've gone to court over that a couple of different times, and the Florida courts have judged that the porter service is not involved. They are not at fault, and they basically let them out of the claim, out of the case. We're going to probably be left standing as the only party. The owners of the Stop and Go Little Quick Mart, they were a mom-and-pop family-owned business, and they, unbeknownst to everybody, had an assault and battery exclusion on their policy, which is very common, particularly for a business of that type. As you can imagine, if they're open late at night, if they sell alcohol, there's people that come in and will assault another person in the parking lot or in the store. So assault and battery exclusions are very common in that industry. And they had an assault and battery exclusion on their policy, so they had no insurance. Their insurance company had denied the claim. So that's the kind of thing that can happen if you don't at least know or try to get what, the best thing we can get as far as the additional insured endorsement. We would prefer the 2001 edition, but in today's market, because it's been 13 years since that edition came out, it's very difficult to get anything better than the 2004 or now even the 2013 edition. That edition, as you can see here, went even a little further to say that if the state statute and its state case law in that particular state will not allow the named insured, let's say the contractor or the vendor, to accept the sole negligence of the property owner, which many states do not allow that. They will not let the contractor accept the sole negligence of the property owner. Then the coverage basically says that if that's what the state law says at the time that a claim occurs, then we will not provide any coverage any broader than what the law allows. The insured coverage, it says in the very dark bold letters, the coverage will conform to the law. And the reason it's a very broad worded endorsement is because laws do change from year to year in particular states. It also says in the bottom box that the coverage itself will not be any broader than required in the contract. So if the contract has a very narrow scope of what they're supposed to be providing as far as indemnification or coverage, then the policy will only respond to as broad as the contract wording is, not any broader. But back in November of 85, and back in October 2001, if a claim occurred, every insurance carrier pretty much had to pick up, defend, and indemnify the additional insured, regardless of who was at fault or what occurred. That began to be, degraded or deteriorate in 2004, and it's continued on. All right, Laura, you go on to the next one. So that was the endorsement, and now we're going to get into the insurance certificate, because the two go hand in hand. Really, there are three parts. You've got your contract wording, you've got your endorsement, and you've got your certificate. In 2003, 11 years ago, people used to be, and some of you may think that it's still there, but it's not. There used to be words on the certificate that said that the certificate conveyed all the rights and privileges under the policy to whoever was named on the certificate. That's been gone now for 11 years. It took a few years for people to stop using those old certificates, but it is virtually gone now. If you see one that still has that wording on it, that's very much an anomaly, because it actually is illegal in most states now and very much a violation of each state's insurance department, insurance commissioners' executive orders. So it is very much frowned upon, and insurance agents can actually be fined for using old editions, like just pulling something out of a box and typing up on an old Accord form, which is what the company's name is, ACORD, that produced certificates. They can be fined for that, and they can have their license suspended if they're really bad about it, or you have their license revoked if they're bad about it. Also in 2009, the cancellation provision that we all used to see that said that they would endeavor to mail notice of cancellation to whoever needed to have it within a certain number of days, that's been changed as well. And now the wording says that the cancellation notification would be provided as stated in the policy. In addition to not being able to use those old Accord forms, those old certificate forms, it is also illegal and in violation of insurance laws in most states in the union, probably all by now. That's kind of come over a period of the last 2 or 3 years and significant changes. The agents and brokers can no longer type anything on a certificate or on the second page of a supplemental page of a certificate unless it's in the policy verbatim, word for word. If they don't schedule, for example, a construction project to the policy using that construction project number and the name of that project, if it's a blanket and not scheduled individually, they're not even allowed to type the project number on the certificate any longer in that description box at the bottom. So I'm sure some of you have got letters from insurance agents about that, and that is true. Some of them have kind of gone to the nth degree where they said they can't type anything at all on the certificate. We don't think that's correct. In the legal world, we believe that they can still put it on the certificate, I would say, in most every state that I know of, as long as it is, again, verbatim, word for word, just extracting the wording from the policy and not taking any artistic effort to change it around or make it shorter, but word for word. All right, Laura, you can go on to the next page. All right, the next step. What do we do, and how can we be protected? And there I would tell you that that's a precarious situation that we're in. Okay, Laura, you can go on to the next one. Again, here we were, the 11 of 85, CG 2010, and then Laura, you can go on to the next one. And here we are with the 10 of 01. So let's talk about what we can do and what we're going to be getting. The first thing that we're going to have to do over a period of time, and it's going to take a long time, is as leases come up for renewal, as vendor contracts come up for renewal, as you hire or our tenants hire contractors and subcontractors, we're going to have to request the correct endorsements or the ones that we prefer. So in the area of the agreement, and I would tell you that I know there's at least one property management company that we have that I've seen their letter, and I actually think, and they'll laugh if they're on the phone, in their little group, that many, many years ago, my company actually was their insurance agent, and we helped draft that letter 20 or 25 years ago. I was at Pritchard and Jerden 26 years tomorrow, and we helped draft that letter many years ago, and they're still using some format of that letter. What we need to do in those letters that we send to the tenant, to the contractors, you know, or even in the agreement itself when you first do the agreement, we need to put in there that the additional insured endorsements that they have to provide to us that will name the owner and the property management company as additional insured are the CG 2010 10 of 01, this one right here on the screen, the CG 20101001, and the appropriate spaces in between to delineate the number and the date, and the CG 2037 10 of 01. So the only numbers that would be different is 37 where the first number 10 is. You want both of those endorsements. So how we word that is usually to say that the additional insured endorsements that need to be provided are these two, naming the owner and the property manager as additional insured. That's our most preferred. The next line of defense that we have, because you're going to have some contractors and some vendors and even some tenants that are going to come back to you and say, my insurance company can't give me that. The only ones they can give me are the 0704, which is the July of 2004. That's what, the 0704. That's the only edition date they can give me of those. And if that's the only edition date they can get, which if they're telling you that, that's probably the case, then you have to take that. Or if they tell you all they can get is the April of 2013, then that's what we're going to have to take. You will have people that will not balk at it. They'll see it in the agreement. They'll think they can do it. And then you'll get their endorsement, and they're not the ones that are in the contract. Well, that's obviously a problem, but again, it's a problem they may not be able to resolve, because a lot of times the deal guys that are signing these leases, or even, frankly, the attorneys for some even larger tenants, they look at these things and don't give them to the risk management people or the insurance brokers, the contract, and then 2 months down the road, when we sign the lease and they have to provide the certificate and the endorsement, it's not the one that's in the agreement. So therein lies the problem. But we need to at least ask for those specifically. The second issue that many of you are aware of that is another problem is are all the names of the entities for the different funds that Prudential has. As you are aware, I'm sure many of you, we have 2 funds that are now REITs, and that is PREI that became a REIT effective January 2013, and PREI 3 that became a REIT, I think I want to say maybe 2010, but it could have been earlier than that. I've got the date somewhere. Both of those are REITs, and because some of the parties that are in the structure chart of those REITs are not considered full members. They are considered sub-members and have other relationships to the owner entity. Prudential in-house counsel wants us to have all of those entities named specifically in the agreement. That's definitely going to be a sidebar, not something we're going to address in depth in this webinar today. We are going to again do more in-depth training in the first and second quarter of 2015. But if you have questions about what entities need to be named, we will do everything we can to help you determine what those names should be. You can come to either any of us, Pritchard and Jerden. You can go to the asset manager or their analyst. Anybody that you think might have that information, if you are a property management company that you're also a partner in the deal, you can also go to your corporate office to say, do they have a copy of the structure chart? And we can help you with that. I would say that right now, while we're going through our renewal on it's going to be 12/31, it's better if you would contact us probably after the week of the 5th, so sometime after that week, because we're going to be putting a lot of stuff to bed that week. So maybe starting the week of the 12th of January, we could help you a lot more. If it's something that's a very quick question, you've got your names, you just want to verify it or something like that, that's a quick fix. But anything more in depth than that, we're probably going to have to wait now that we have got this issue with PREI not being renewed. So we need to wait until then, but we will be able to help you at that point. There will be more in-depth training. And if you're lucky enough to get the CG 2010 and the CG 2037, typically and theoretically, all the names that we need to have listed should be typed in that box that says name of person or organization. And if you're not lucky enough to get those, then we'll go on to the blanket ones. I'll tell you about those. Or you can go on to the next one. And this is the 07-04 edition of that same endorsement, and then you can go on to the next one. And then there's the 413. Again, the CG 2010 is the premises, the operational piece, while they're on the property. You never want to have one without the other, because then you've only got half. You've got the CG 2010. We're all covered while they're there. If they leave the property and 3 months later a wall collapses and kills 2 people, then if you don't have the CG 2037, you don't have any coverage after the fact on their policy. It would come back to all of us, not to them necessarily, because you wouldn't have additional insured status for their completed operations for what they did. But so you want those. All right, Lori, you can go on to the next one. That's just the second page. The 413 ones are 2 pages because they're adding a lot more disclaimers to them. This one, again, is the CG 2011. The CG 2010 and the CG 2037 are endorsements that you would primarily see with contractors, subcontractors, vendors, anyone providing a service, just not someone that's a tenant. Now, in your leases, you would have typically that the tenant would provide you additional insured status for the owner and the property manager, and that one could be provided by using the CG 2011. But if you have the contractor, subcontractor wording in the lease, saying that if they're going to hire someone, they have to provide additional insured status to the owner and the property manager, you want that to still be the 2010 and the 2037 for anybody that's in a trade like that, subcontractor, contractor, window washer, carpet layer, even anybody coming in installing, in my opinion, installing water filters and purifiers, if you know that they're coming in and doing it even, because we've had quite a number of very large water losses from people doing things like that, installing coffee makers and water filters in tenant space underneath their sinks. So this would be the one from the tenant. It's additional insured managers or lessors of premises, and it would have the designation of the premises, the name of the organization, the property management company entities or our owner entities would be typed in that schedule there. And Lori's on the next one. This is the infamous 2033, and this is where the rubber meets the road. This is what most insurance companies want to use and are using now. This simply says in letter A, section 2, who is an insured is amended to include as an additional insured any person or organization for whom you are performing operations when you and such person or organization have agreed in writing in a contract or agreement that such person or organization be added as an additional insured on your policy. So it's whatever's agreed to in the contract. So with all those names that we have, if we've only said owner in the contract, then literally in most cases only the owner entity, the single purpose entity, if that entity is named that in a lawsuit, that would be the only one that they would want to cover. If they don't name that entity, which happens, as some of you know, a lot, and they name Prudential Investment Management or the Prudential Insurance Company of America because they know those names and those names are big targets, then most of your vendors, contractors, and subcontractors, their insurance carriers are going to balk at defending and indemnifying that entity if it's not the entity name on the contract or in the contract. That's why we want to name all of the entities that could possibly be named up the structure chart or down, whichever way you want to look at it, because this is literal. If it's not in the agreement, then we could be out of luck. Now, this 2033 is it's the premises equivalent of the 2010, and so this is only for premises, but it's used in place of the 2010. So this 2033 is a blanket 2010. So look at it that way. It's a blanket 2010 where the 2010 would have the name types in it. This one is a blanket. So again, it needs to be in the contract. If your certificate is correct in every way, your certificate means nothing. If you've got this blanket, additional insured endorsement, and your certificate is correct, but your contract is not, you don't have coverage for the entities that are not named in that contract. So it's going to take a long time for us to get to that point with some of these leases and possibly long-term agreements that we have with vendors. There are going to be some properties and some asset managers. We've had some conversations with some different groups that are willing to take on the challenge of trying to get all their agreements amended and all their leases amended over the next year. But it could take, at some properties, as long as 5, 10, or 15 years to go through the cycle of getting all these things up to date. But going forward, if you're entering into a new lease or a new contract, you need to make sure that the right wording is there. Either you need to make sure outside counsel is looking at it. Somebody, if we all keep our eye on the ball, it will be a lot more effective over a longer period of time if we're all cognizant of this fact, that you literally could execute agreement where people don't have coverage at all. I have seen agreements in the last year or two where construction managers, property managers, parties that were very important to the deal, they've not even been listed in the agreement by category. It's not said that the owner and their property manager are additional insured. It just says that the owner is an insured. I'm sorry, an additional insured. Well, that's great for the owner entity, but that's not so great for the property management entity if you're named in a lawsuit. And we see sometimes that just the property management entity is initially named in the lawsuit because that's the name everybody sees on the signs out front or they know. And then they have to amend the complaint as time goes along, but there's defense costs that build up over that period. And you would want to make sure that you're covered under the GC's policy as well. Now, you do have a backstop in that you've got the owner's coverage on a primary basis if you can't get the general contractor to take care of you, and then you've got your own corporate coverage. But we really want the claim to go to the appropriate place, which is the party that's responsible, the contractor, the subcontractor, the vendor, or the tenant. All right, Lori, on to the next one. The second page of that 33. And then this is the series of I think we only have one of the 2037, but the 2037, as you can see at the top, says additional insured owners, lessees, or contractors for completed operations. And that's, again, for what happens after they leave. Wall collapses down the road, the building starts leaking like a sieve, whatever, that's the after the work's been done coverage. All right, Lori's going to the next one. And we do have 27. There's the 0704. You keep going. And there's the 0413. This one has the second page, I think, of that one next. Oh, no, that's just one of one, I guess. The next thing is we're going to talk about very briefly, trying to stay within our hour, is the certificate of insurance. The Accord 25, as many of you may know, is the general liability certificate. That's the standard. We still occasionally see what they call an Accord 25-F, but actually that certificate form has been removed from the market for probably 10 or 20 years. So if you get a 25-F, you're probably not dealing with a very sophisticated or very large insurance broker. It's probably someone that's a smaller operation, mom and pop type operation. but it's normally normally Accord 25. The Accord forms changed dramatically in 2009, 2010, and they're not what they used to be. Even what they used to be wasn't very much, but what they are now is basically a piece of paper. It really is, unfortunately, the only way in the industry you're going to even know that there's possibly some insurance there. And you can't be 100% sure. You're not going to be able to get typically copies of policies because most people have multiple exposures on their policies, things that they don't think is your business, so they're not going to give you a copy of their policy. You might be lucky to get what we call a redacted copy of a policy, if somebody's willing to give you one, but that's usually very rare as well. But I would say that your certificate is your best line of defense. That would be all you would expect to be getting by the property owner. They would not expect you to be able to get a policy from everybody that you deal with. And again, we just have to rely on it. That's all we've got in the industry. And they can be fake. They can have, information on there. You can have a poor vendor somewhere that's given their money to an insurance broker that's not reputable, and that broker has put that money in their pocket, and they've issued certificates. I mean, I've seen it been issued for workers' compensation coverage even in the city of Atlanta. And people have been busted for doing that because there was all of a sudden a bad claim, and there was really no insurance. The insurance agent had been pocketing the money, and there has been no insurance. So it's usually a very sad situation for the party that's been injured or for the family of someone that there is no insurance in place, and by that point, there's nobody to go after because everybody involved probably absconded or spent the money and they're judgment proof. So it's just a sad situation for those people. So Lori, you want the next one? This is what I really wanted to focus on for the last couple of minutes of our call today, is the certificate of liability insurance. The boxes in yellow are the critical pieces. At the top, as you can see, the certificates all clearly now say that this is a matter of information only. It confers no rights, and that it doesn't affirmatively or negatively amend, extend, or alter the insurance coverage afforded by the actual policies. The certificate does not constitute a contract of any kind between the issuing insurers, the authorized representatives, or the producer and the certificate holder, because as you can well imagine, you've got insurance brokers and agents in some cases out there, not a lot of them, but there are some that are not reputable, and they're issuing certificates that are erroneous. So they want to make sure that this Accord wants to make sure as an industry standard, this document says that even if an insurance agent issuing one, they are not authorized to issue something that's not true. So you could go after the agent, errors and omissions or professional liability coverage, but it's not probably going to tie the insurance company to anything on this piece of paper. The next box is vitally important. This is something that's new on the Accord form in the past 3 to 5 years. Depends on what agent has been using them. They've taken time to get to using the current forms. But it says if the certificate holder is an additional insured, the policy must be endorsed. If you don't have the endorsement, you have nothing. If subrogation is waived, so there's a waiver of subrogation in the agreement, subject to the terms and conditions of the policy, certain policies may require an endorsement. And typically that would be your liability policies. Most property policies have an automatic waiver of subrogation built in between a landlord and a tenant for property claims, but not for liability. So your liability policies would be the ones, that or your work comp policies as well, and auto liability. But anything that's listed on here like work comp, umbrella, auto liability, general liability, those typically have to be, in many cases, endorsed for waiver of subrogation. A statement on this certificate does not confer rights to the certificate holder in lieu of such endorsements, meaning both the additional insured and the waiver of subrogation. So even if you have it written in that description box, which I'm sure every one of you see every day, that whatever entities, 3 of them, 6 of them, 12 of them, are additional insured, being on this certificate means nothing. That's it. You can get this certificate correct to the T all day long, and it means nothing to you. It means nothing to anybody, other than it's just a specimen to show you that they possibly have insurance, but you need to get the endorsement. So you need to be asking for the endorsement. primarily the additional insured endorsement. If you've got time and want to do it, think you can get it, or just you can ask for it, and if you don't get it, you may not get it. You could ask for also the endorsement that provides the waiver of subrogation, and in the bottom in the right-hand side, cancellation. If the owner, landlord, property management company, if the contract says review a notice of cancellation for like 30, 60, 90 days before the policy is canceled, you can also ask for a copy of the notice of cancellation provision or endorsement to the policy, because that notice of cancellation can be part of the policy form, or it can be a separate endorsement. You can ask for that as well. But in my opinion, to spend your time wisely, the most critical part is getting a copy of the additional insured endorsement or endorsement. There could be one, or there could be two, or there could even be three. There could be one from the tenant, and there could be two from their contractor coming in to do tenant improvement work on the inside of their space, whether it be minor, moderate, or major. You could have multiple endorsements, and you want all of those endorsements to include all the parties that need to be included, and you want all the contracts that are involved. Both the contract if you're hiring the contractor or subcontractor, or the agreement where the tenant is hiring the contractor or the subcontractor. You want to make sure to provide the tenants with the list of the names in their new leases that come up, or in their renewal of their leases, the list of names they need to make sure that they provide us additional insured status for, or that they make their contractors or subcontractors or vendors provide the additional insured status for. And again, this is very complicated. We're going to do more training. Laura, I think that might be the last slide. I'm not sure. Oh no, benefits of getting certificates. This is just something for you to read. People wonder, well, why in the world, should we even bother to ask for them? I mean, it's too complicated. But as you can see in the second bullet point, case law indicates that not demanding a certificate can lead a court to conclude that the upstream party has waived the downstream party's obligation to procure the related or proper insurance, in my opinion. So if you don't ask for a certificate at all, if you had to go to court over an issue, the court could deem that you not asking for a certificate for a year or two, or even sometimes I'm sure less, that it made the party that needed to give you a certificate, they weren't responsible for what they needed to obtain as far as insurance, because you weren't concerned enough to even ask for the certificate or ask for the right document. I would say, in my opinion, as long as you document that you requested the certificate and that you requested the endorsement, you may or may not get them, but you've at least got documentation that you did try to get them, and you've used every commercially reasonable effort to get them. And I think you're going to be, as the property management company, a lot better off and protected against scrutiny by someone else if you've at least got documentation that you did try to get them. Laura, I think there was another one. That's it. Again, we're going to try to stay within the hour. We are going to schedule more training, probably one or two webinars in the first quarter of 2015, and possibly another in the second quarter of 2015. Depending on the feedback we get from people about what they want to know, we're going to drill down further into that. I would tell you that your best line of defense going forward immediately is to make sure that you know all the names for your particular property of the ownership entities that you need to have in all of the agreements, and you just type that up into a little sheet of paper, and you slap that out there or hand it to everybody and tell them, if a new contract's done, all these names have got to go into that agreement. That's going to be your best line of defense immediately going forward. And again, we can help you a lot more the week of January 12th, but that's at least kind of putting you on notice that that's what you need to be doing going forward with every agreement you're looking at, leases, renewals, contractors, vendors, so on and so forth. We appreciate your time, and if you have any questions, please feel free to email any of us, and we will try to get back to you with what's going on as soon as we can. Have a great afternoon.
Thanks, everyone, for your time today. Just so you know, this webinar will be recorded and posted to the Pritchard and Jerden website that you all should have access to. It's the same website where you go for claim information. If you have questions about your login credentials or you do not remember them, feel free to send me an email and I will get you set up. I hope everyone has a great day, and thanks again for attending.